So, next is Title 6, Paternity and Filiation, Chapter 1, Legitimate Children. Article 163, Filiation of children may be by nature or adaptation. Natural filiation may be legitimate or illegitimate. So, legitimate was a children who born in a valid marriage, and to the following article, we will discuss the other matter. Can you read the Article 164? Thank you for reading. So, this Article 164, pag sinabing legitimate children is when the children conceived or born during the marriage of parents. It is called legitimate. So, ibig sabihin, yung mga babaeng nabuntis o mga napakasalan is matatawag na legitimate yung kanilang mga anak. Hindi ito tinawag ng batas na illegitimate dahil ang ginamit na salita ay conceive or born. So, ibig sabihin, either at the two, as long as pinanganak ka at the time of the celebration or after celebration of marriage, you are already legitimate. So, Article 165, children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. So, this Article 165 stated that illegitimate child, those who are conceived and born outside of wedlock. Outside of wedlock, possible na nabuntis and other possibility ay nagkaanak sa ibang babae or sa ibang lalaki. So, it means conceived and born. So, can you read Article 166? Oh, thank you. So, ito naman yung mga usapang mana kung paano mapapatunayan na ikaw ay anak or hindi. So, may tatlong klase kung paano ka mapoprove na ikaw ay anak or not. So, first, to prove na hindi ikaw ang anak, physically incapable. Physically incapable to sex intercourse. The mother and the father are physically impossible. Halimbawa, naghiwalay na si nanay at tatay. So, paano nanganak si nanay? For example, first 300 days before the birth of the child, wala naman silang sexual intercourse because the mother or the father was in the other country and the mother was in the Philippines. So, paano nabuntis? So, physically incapable yun because of physical separation. And the other example of physical incapable is may sakit si nanay or si tatay. Physically incapable yun. So, first is the physical incapable of sex intercourse. Second, na para ma-prove na ikaw ang tatay is let's use the biology or the science. Dito papasok ang DNA test. So, third is hindi mo na-comply ang artificial insemination law. Dapat may pirmahan bago ipanganak ang bata. Perma ni nanay at tatay na kinakailangan na authorized at nakaregister sa NCR. So, Article 167, the child shall be considered legitimate although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. So, Article 167 stated that kahit anong sinabi ng mother na hindi mo ito anak, sasabihin ng nanay yun para mapabroke lang yung tatay. Kasi, there's a circumstances that nagkakaroon ng bagong jowa ang tatay. So, nagalit si nanay. Ngayon, si tatay lang makakapagtanong nito kahit sabihin ng mga nanay na hindi ikaw ang tatay, walang bisa yun. So, yun ang nakapaloob sa Article 167. Okay, again, can you read Article 168? Thank you for reading. So, 168 stated that if kung ang bata ay pinanganak before 180 days, ang presumption dyan ay hindi anak ng bagong karelasyon, kundi yan ay anak ng dating karelasyon. Before 4 months, dun ka sa dati. Pag after 4 months, dun ka sa bago. Article 169. The legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by who alleges such legitimacy or illegitimacy. So this article stated that no presumption for a child born after 300 days after termination of marriage. The longest gestation period of a child in the mother's womb according to law is 300 days. The father of a child born 300 days after termination of the first marriage in the absence of subsequent marriage can be anybody, while there had been cases where the gestation period reached up to 316 to 330 days. This is not normal. Hence, Other convincing proofs of violation must be shown. Evidence may be introduced by whoever alleges the legitimacy or illegitimacy. So, can you read Article 170? Thank you for reading. So, 170. So, nalaman mo na isinilang ang bata within 1 year from knowing na isinilang ang bata or 1 year from recording of the birth sa civil registration. You should bring action within 1 year from that time. 1 year from the birth of the knowledge of the birth or 1 year from the registration. Before, 1 year in the same city. But now, if the father is an OFW and nalaman na lang niya, after 3 years, so pagbalik niya dito, may 3 years siya para mag-question. So, can you read again the 171? Thank you for reading. Article 171. Impugn is dispute the truth. So, sinabi na nga sa mga previous article na hindi maaaring si mother ang mag-impugn ng child niya. Kasi nga, siya ang nagdala or siya ang nagbuntis. Kung namatay ang tatay bago mag-expired yung panahon ng kanyang aksyon, mas magandang ayusin na lang. At kung namatay pagkatapos mag-file ng complaint nang walang napipilitan at kung ang bata ay napanganak after the death of the husband. So, Chapter 2, Proof of Filiation. So, this article was for the legitimate children. So, this article 172, kabilang dito ang birth certificate or other proof na pwedeng patunay na ikaw ay anak or hindi. Before kasi, hindi pa ina-acknowledge sa Philippines dahil sa kakulangan sa mga facilities. Pero sa panahon ngayon na medyo bumaba na ang price ng mga DNA, so madali nang mapapatunayan.
Ayon sa Article 173, ang pagiging lehitimong tagapagmana ay dadalhin ng isang bata hanggat siya ay nabubuhay at ito ay maipapasa lamang sa mga susunod na mga tagapagmana kung ang bata ay mamamatay o mababaliw. Ayon naman sa Article 174, ang mga tunay o lehitimong bata lamang ang may karapatan upang magdala o magamit ang apelyido ng ama at ina. At upang ito ay maligal, kinakailangan na dapat maisabatas. Ikalawa, upang makatanggap ng suporta sa mga magulang, kailangan na ang bata ay legal at nasa ibatas ang dinadalang apelyido na nakalagay sa mga probisyon. At upang ang bata ay magkaroon ng karapatan sa pagiging legal o lehitimo at iba pang karapatan, ito dapat ay legal at nasa ibatas na ipinagkaloob ng Code Civil 264A. Ayon sa Article 175, ang mga lehitimong bata ay maaaring mapatatag ang katotohanan bilang anak ng kanilang magulang sa parehong paraan bilang isang lehitimong bata. Ayon naman sa Article 176, if you are a legitimate child, you should use the surname of your mother, but you have an option to use the surname of your father. Ngunit dapat na kinikilala siyang anak ng kanyang ama, at dapat ang ama ay nakapirma ng affidavit of acknowledgement o nakapirma sa birth certificate ng bata. At kung wala ito ay hindi magagamit ng bata ang apelyido ng ama. Ayon sa Article 177, kung ang bata ay ipinagbubuntis ng hindi pa kasal ang magulang at ipinanganak na kasal na ang magulang, ito ay nangangahulugan na matatawag ang bata na legitimate child. Ayon sa Article 178, ang legitimation ay nagaganap kasunod ng valid na kasalan o pagpapakasal ng magulang. Kung magkaroon man ng annulment ay hindi nito maapektuhan ang pagiging lehitimo ng. Ayon sa Article 179, ang legitimated at legitimate child ay marapat na mayroong magkatumbas na karapatan. Ayon sa Article 180, ang pagiging legitimate ng bata ay iiral sa kapanganakan nito kung ang magulang ay kasal o ikinasal. Ayon naman sa Article 181, ang mga bata na namatay bago ang pagdiriwang ng kasal ay makikinabang sa kanilang mga inapo o apo sa kasunod niyang mabubuhay na anak. Ayon sa Article 182, kapag ang bata ay wala pa sa edad o hindi pa sapat na kanyang kakayahan upang akuin ang naiwang ari-arian o pera ng magulang, maaari itong akuin ng mas nakakatandang kamag-anak. Ayon sa Article 183, ang taong nais mag-ampon na nasa edad na ay dapat may kakayahang tustusan at pangalagaan ang kanyang mga magiging anak, lehitimo man o iligal ito. At marapat lamang na ang mag-aampon ay 16 years old pataas at mas matanda kaysa sa aampunin niya. Ayon sa Article 184, ang mga sumusunod na tao ay hindi dapat mag-ampon. Una, ang tagapag-alaga o di kaya ng kamag-anak gaya ng tiyahin, tiyo, kapitbahay o kung sino paman hanggat ito ay walang apruba ng guardian o magulang ng bata. Kalawa, isang tao na may kaso at nahatulan ng krimen. Pangatlo, isang dayuhan, maliban na lamang kung ito ay isang dating mamamayang Pilipino. Ayon naman sa Article 185, ang mag-asawa ay dapat na magkasama mag-ampon maliban sa mga sumusunod na kaso. Una, kapag ang mag-asawa ay naghahangad na mapagtibay ang kanyang sariling ilegal na anak. Ikalawa, kapag ang isang asawa ay naghahangad na gamitin ang lehitimong anak ng iba. Ayon naman sa Article 186, kung sakaling ang mag-asawa o ang isang asawa ay mag-ampon ng lehitimong anak ng iba, pangkasamang otoridad ng magulang ay dapat magampanan ng mag-asawa aling sunod sa batas o code. Ayon sa Article 187, ang mga sumusunod ay hindi maaaring ampunin. Una, ang taong nasa legal na edad na. Ikalawa, ang mga dayuhan na walang relasyon ng kanilang pamahalaan sa ating bansa. Pangatlo, isang tao na pinagtibay maliban na lamang kung ang naturang pag-aampon ay binawi o pinagwalang bisa. Ayon sa Article 188, ang nakasulat na pahintulot sa pag-aampon ay kinakailangang una, ang taong aampon kung 10 taong gulang ang aampunin o higit pa. Ikalawa, ang magulang ng bata o ang legal na tagapag-alaga na nasa batas ng gobyerno. Pangatlo, ang lehitimo o legal na mga anak na 10 taong gulang o higit pa na pinagtibay ng mga magulang. Pang-apat, ang mga illegal na anak na 10 taong gulang o higit pa kung ito ay nakatira sa mga magulang o asawa sa huli kung mayroon man, o pangalawang asawa o illegal na asawa. Ayon sa Article 189, ang pag-aampon ay magkakaroon ng mga sumusunod na epekto. Una, ayon sa layunin ng sibil, ang pinagtibay o naisabatas na dapat na ituring ng nag-aampon na lehitimong anak o legal na anak ang inampon at dapat ito ay may pantay na karapatan mula sa mga umampon at dapat gamitin at dalahin ang kanilang apelyido. Pangalawa, ang awtoridad ng mga tunay na magulang ay dapat wakasan at dapat ibigay sa mga umampon at ito ay dapat pagtibayin sa pagitan ng mag-asawa. Ayon sa Article 190, ang mga sumusunod o legal na pag-aari ng inampon o pinagtibay ay pamamahalang mga sumusunod na patakaran. Una, legal man o illegal na maging anak ng inampon o pinagtibay sa ari-arian ng pinagtibay o inampon, hanggang kamag-anak at kaapu-apuhan ay magmamana mula alinsunod sa patakaran na legal. Ikalawa, kapag ang magulang, legal man o hindi legal, ng inampon o pinagtibay ay humati sa mamanahin nito at pumayag ang pinagtibay ay hahatiin ang mana nito. Ikatlo, kapag ang asawa o ang mga anak ng ilihitimong anak ng pinagtibay ay sumang-ayon sa mga nag-aampon na hatiin nila sa pantay na bahagi ang minana nito. Pang-apat, kapag ang umampon ay sumang-ayon sa mga iligal ng anak at asawa ng pinagtibay na hatiin ang minana, ito ay hahatiin sa pantay-pantay na bahagi. Ikalima, kapag ang umampon lamang ang natira o nanatili, ay siya lang o sila lamang ang magmamana ng buong mana. Pang-anim, kapag ang collateral na kamag-anak lamang sa dugo ng pinagtibay ang natira, ito ay magmamana ayon sa ordinaryong patakaran. Ayon sa Article 191, kung ang isang batang aampunin ay menor de edad o kung siya man ay may kakayahan na, ang nasabing pag-aampon ay maaaring maalis ayon sa judicial na petisyon ng sino mang tao na pinahihintulutan ng korte. Kung ang pinagtibay o aampunin ay higit sa 18 taong gulang, ay maaari din siyang magpetisyon para sa paghatol ng panghukuman na pag-aampon. Ayon naman sa Article 192, ang mga nag-aampon ay maaaring magpetisyon sa korte tungkol sa paghahatol ng hukuman sa pag-aampon, alinman sa mga sumusunod na kaso. Una, kung ang nag-aampon ay gumawa ng anumang kilos na bumuo ng isang batayan para mapawalang bisa sa isang supling. Pangalawa, kung ang batang inampon ay umalis sa tahanan ng mga umampon sa kanya sa panahon na siya ay minor de edad at hindi bababa sa 1 taon, nangangahulugan lamang ito na ang pag-aampon ay tinatanggihan. Ayon naman sa Article 193, kung ang umampon ay menor de edad at hindi wasto ang edad para umampon, ito ay hahatulan ng korte at ibabalik ang awtoridad ng tunay na magulang maliban na lamang kung ito ay walang kakayahan para alagaan ang bata. Sa ganitong kaso, ang korte ay magtataglay ng isang tagapag-alaga na tao sa pag-aari ng menor de edad. Kung ang taong pinagtibay ay may kapansanan sa pisikal o utak, ang korte ay dapat magtalaga ng tagapag-alaga sa tao at pag-aari nito. Ang judicial na pag-aampon ay tatanggalin ang lahat ng karapatan, katumbas at obligasyon sa pagitan ng mga adoptor at ang pinagtibay na nagmula sa ugnayan ng magulang at anak. Mawawala din ng karapatan gamitin ang apelyido ng mga nag-ampon at ibabalik ang kanyang pangalan sa dati.
Zyril A. Kabile, and my report is all about the professional teacher, Conformers of Legal and Constitutional Mandates, Title 8, Support. Article 194. Support comprise everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. The education of the person entitled to be support referred to the preceding paragraph shall include schooling or training for some profession, trade or vacation even beyond the age of majority. Transportation shall include expenses in going to and from school or to and from the place of work. So support includes whenever it's necessary to keep a person alive, including natural support like companionship, shelter, or anything that is established based on everyday's need. And civil support, that is anything beyond the basic necessities. Article 195, subject to the provision of the succeeding articles, the following are obliged to support each other to the whole extent set forth in the preceding article. Number 1, the spouse. Number 2, legitimate descendants and descendants. Number 3, parents and their legitimate children, and the legitimate and illegitimate children of the latter. Number 4, parents and their illegitimate children, and the legitimate and legitimate children of the latter. And number 5, legitimate brothers and sisters whenever full or half-blood. So support is a mandatory action. Both spouses are obliged to support their children whenever it is legitimate or illegitimate because it is important obligation imposed by the law. Article 196. Brothers and sisters not legitimately related, whenever the full or half-blood, are likewise bound to support each other to full extent, support in Article 184, except only when the need for support of the brother or sister, being of age, is due to the cause of imputable to the complainant's fault or negligence. So if the brother and sisters are not legitimately related, they are entitled to support each other. However, support will be not given at all if the brother or sister cause negligence. Article 197. In case of legitimate descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that, in case of the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or the conjugal partnership. So in Article 197, if the person asks for the support and don't have the capacity to give such support demand, the spouse will shoulder the responsibility in terms of the conjugal properties, earnings. Article 198. During the proceeding of legal separation or for annulment of marriage, the spouse and their children shall be supported from the properties of the absolute community or partnership. After final judgment, granting the petition, the obligation of mutual support between the spouse ceased. However, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent spouse, specifying the terms of such order. So in Article 198, if separation of marriage between husband and wife has been occurred, their child shall still receive support from their properties. Article 199. Whenever two or more persons are obliged to give support, the liability shall devolve upon the following person in order herein provided. Number 1, the spouse. Number 2, the descendants of the nearest degree. Number 3, the ascendants of the nearest degree. And number 4, the brother and sisters. Article 200. When the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may only choose one in them to furnish support provisionally, without reduce to his right to claim from the other obligors and share due from them. When two or more recipients at the same time claim support from one and the same person legally obliged to give it, should the latter not have sufficient means to satisfy all claims, the order established in the preceding article shall be followed unless the concurrent obligors should be the spouse and the child subject to parental authority, in which case the child should be prepared. So in Article 199 and Article 200, the law sets order to the presence of the person who has ability to give support financially in any circumstances in order to follow support that shall or needed to given to the child. Article 201. The amount of support in the cases referred to in Articles 195 and 196 shall be in the proportion to the resources or means of the giver and to the necessities of the recipient. Meaning to say, if ever the Articles 195 and 196 happen, the amount of the support will be based on the amount of the supporter's salary and will be based on the need of the persons who needed support. Article 202. Support in the cases referred to in the preceding article shall be reduced or increased proportionately, according to the reduction or increase of the necessities of the recipient and the resources or means of the person obliged to furnish the same. So in this article, the amount of support can be reduced and increased depending on the person who needs support and will be based on the person's resources who is responsible in giving support. The obligation to give support shall be demandable from the person who has a right to receive the same need it for maintenance, but it shall not be paid except from the date of judicial or extrajudicial demand. Support be claimed in accordance with the rules of court. Payment shall be made within first 5 days of each corresponding month or when the recipient dies. His heir shall not be obliged to return what he has received in advance. So in Article 203, the support shall be given according to the demand of the person who needs support and will be based on the decision of the court. Article 204. The person obliged to give support shall have the option to fulfill the obligation either by paying the allowance fixed or by receiving and maintaining in the family dwelling to the person who has a right to receive support. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. So in Article 204, the obligor is given the choice as to how he could dispense his obligation to give support. It also is stated that to fulfill this obligation, he may choose between paying the amount fixed or receiving and maintaining in the family dwelling to the person who has right to receive the support. Article 205. The right to receive support under this title as well as any money or property obtained as such support shall not be levied upon an attachment or execution. So under this title, support of either of money or property shall not be levied for any taxation. Article 206. When without the knowledge of the person obliged to give support, it is given by the stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it without any intention of being reimbursed. Article 207. When the person obliged to support another unjustly refuses or fails to give support when urgently needed by the latter, any third person may furnish support to the needy individual with the right reimbursement from the person obliged to give support. These articles shall particularly apply when the father or mother of the child under the age of majority unjustly refused to support or fails to give support to the child when urgently needed. So in Article 206 and 207 specifically provides that parents are obliged to give support to their dependents. However, in the instances where there is some unavailability of such support to comply, instead, a third person represents the obligation need, unless he decided not to claim such reimbursement in favor of the recipient. Article 208. In case of contractual support or that given by will, the excess of amount beyond the required for legal support shall be subject to levy on attachment or execution. Furthermore, contractual support shall be subject to adjustment whenever modification is necessary due to changes in circumstances, manifestly beyond the contemplation of the parties. So when we say legal support, it is mandated by law to be given, and which is provided in Article 194, where we tackle about the natural support and the civil support. And when we say contractual support, it is the one which is entered by the parties, usually with reciprocal duties and obligations. Title 9, Parental Authority, Chapter 1, General Provision, Article 209. Pursuant to the natural right and duty of parent over the person and property of their emancipated children, parental authority and responsibility shall include the caring for the rearing them, for civic consciousness and efficiency and the development of the moral, mental, and physical character as well as the well-being. So in Article 209, the natural affection between parent and child has always been recognized as natural right. As for parents' primary obligation is to be responsible in taking care of their child, and as for parental authority, parents should do their duty under the law of nature as well as the common law to protect the children. Article 210. Authority and responsibility may not be re-announced or transferred except in the cases authorized by law. As we know, parental authority is a sacred entrusted to parents. So it cannot be simply transferred or re-announced except it was given by the law. Article 211. The father and the mother shall jointly exercise parental authority over the person of their common child. In case of disagreement, the father's decision shall prevail unless there is a judicial order to the contrary. This article provides that the children shall always observe respect towards their parents as long as they are under the parental authority. Article 212. In case of absence or death of either parent, the parent present shall continue exercising parental authority. The remarriage of surviving parent shall not be affect the parental authority over the children, unless the court appoints another person to be the guardian of the person or property of the children. So this article tells us that in case of the death of either parents, the one who is responsible in the child support will be given by the court. And in terms of remarriage, parental authority shall be present and shall continue exercising. Article number 213. In case of separation of the parent, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant consideration, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. No child under 7 years of age shall be separated from the mother, unless the court finds compelling reason in order otherwise. Separation parental authority shall be given to any of the parents who may be designated by the court, in case of the parents have separately from each other. Article 214. In case of death, absence, or instability of the parent, substitute parental authority shall be exercised by the surviving grandparent. In case of several survive, the one designated by the court, taking into account the same consideration mentioned in the preceding article, shall exercise the authority. So, grandparents. In the absence or incapability of the parent, the grandparents are the most natural and suitable person to exercise parental authority. So, that is all my report. Again, I'm Cyril A. Capile, and thank you.